Today, we consider adopting rules that would significantly curtail the corrupting influence of pay-to-play. Pay-to-play is the practice of making campaign contributions and related payments to elected officials in order to influence the awarding of lucrative contracts for the management of public pension plan assets and similar government investment accounts. Pay-to-play distorts municipal investment priorities as well as the process by which the investment managers are selected. It can mean that public plans and their beneficiaries receive subpar advisory performance at premium price.
The Securities and Exchange Commission has decided to lay down their law. The time has come for fat cat politicians to stop lapping up donations from Wall Street and live a little leaner on fewer dollars. Of course, that's the way it seems on the base of the issue to them, but there's a whole lot more under the surface, and politicians are not happy. Welcome to MidPoint. He's a partner at the law firm of Pepper Hamilton, concentrating on the practice in security law, Gregory Nowak, and partner at the law firm HoltzmanVogelJosefiak, and a lead attorney in the lawsuit against the SEC on this matter, Jason Torchinsky. Gentlemen, thank you so much for joining us.
Great, nice to be here.
Jason, I'm going to start with you. Have to tell you, there's a lot of people who will look at this and say, wait a minute now. Politicians all just want to get fat. They want money from the corporates, and the corporations are telling them what to do. And I'm sick and tired of corruption hitting my politicians. So, yeah, let's get the money out of their hands. So they're going to look at you and say, why file a lawsuit over this?
Well, the reason we're filing a lawsuit over this is we think that the SEC, the Securities and Exchange Commission, is improperly treading into areas that Congress reserved to the Federal Election Campaign Act. And we think when the SEC tries to regulate in areas that are reserved to the FEC, the SEC's gone wrong, and that's why we brought the lawsuit.
Then why is the SEC getting involved and not the FEC?
Well, that's the whole point. There's nothing in the FEC that restricts contributions to state and local candidates who are running for federal office. It's the SEC that's trying to do this by administrative regulation, and that's not proper.
Now, this does seem to many people to be a minor item, if you will, because there's still always, and you know how the public is, they're going to point to things like corruption in government from big money donors on Wall Street. So doesn't this still lend some sort of a credence to that in the eye of the public, that this is just politicians continuing to seek the opportunity to get more cash for more favors?
Well, I want to be clear. We're talking about contributions to candidates running for federal office. So this rule, for example, in North Carolina, where Speaker of the House Thom Tillis is running against incumbent Senator Kay Hagan, Senator Kay Hagan isn't subject to this rule, but Speaker of the House Thom Tillis is. That's fundamentally unfair. The same thing in Iowa. State Senator Joni Ernst is running against incumbent Congressman Bruce Braley for the U.S. Senate. She's subject to the rule. He's not. In New York, we're representing the New York Republican Party in this lawsuit. State Senator Lee Zeldin is covered by this rule. He's running against an incumbent congressman who's not. It's the fundamental unfairness of this rule where they try to apply it selectively to influence federal elections that we're challenging in this lawsuit.
All right, Greg, to you then, is this fundamentally unfair? Is it simply the matter of the SEC, FEC, or is there more to this?
Well, I think there's more to it. These types of rules have been around for many years. There's a comparable rule that the SEC had promulgated many years ago, applicable to the municipal advisors, and that has withstood challenge on very similar grounds. I do think that some of the recent scandals, most notably the one in New York, where a state official had been found to have accepted significant campaign contributions in exchange for steering investment advisory work to one of his contributors. You know, those types of things, as you said, cause the public to say enough's enough. As to the argument that this is something that the SEC shouldn't be regulating, you have to go through a fairly lengthy syllogism to get to the conclusion that somehow this rule is unfair. First of all, there's the supposition that investment advisors want to make these contributions. Secondly, there's the supposition that the investment advisor would make the contribution to the person that allegedly is aggrieved here. In my experience, and again, I'm an investment advisory lawyer, my clients are ecstatic.
Well, let's then get to the ecstatic side of things then. fair to say that if you take away this money, you're going to have an awful lot of, and again, we're only talking about a couple of instances here, but things always spread sooner or later, that this is going to eventually affect politicians everywhere. They're going to have less money in their pockets. Isn't it still at the end of the day all about how much money you can put in your pocket to help yourself get elected?
Well, I mean, first of all, nothing's going into the politician's pocket. That sort of proves too much. If that were the case, that's out-and-out bribery, and there are statutes against that. We're talking about campaign contributions, and campaign contributions have always been subject to regulation in this country. The recent spate of Supreme Court actions have been dealing with election expenditures, not contributions, and I think the court's been pretty clear that they don't want their rulings under the First Amendment extrapolated to the contribution realm. So, I mean, I think the case, it's an interesting case. I commend the committees for testing the issue because, again, as an investment advisor attorney, one of the issues we're always faced with is how can you even get a hearing on these issues, because oftentimes they get settled out or it's a civil matter and it's impossible to even get a judge to focus on it. So I think in that regard, it's a useful exercise. I do think there's some questions of standing, but they'll all be vetted out by the court. I think there's very able litigants on both sides of the issue, trying to get this before the judge to actually have a hearing.
Jason, let me point to something here that Greg, I'm sorry, did you want to add something, please?
Yeah, I just wanted to make a point that a lot of the recent campaign finance cases from the Supreme Court actually did deal directly with contributions. The McCutcheon case was all about contributions to candidates and political parties, and that's exactly what we're talking about here. So in McCutcheon, the court said, guess what? You have a right to do this. And government, you don't get to choose how to limit contributions. And the other frustrating thing about this is the only case that we're aware of, other than the one case that Greg talked, the one regulation from 20 years ago that Greg talked about, where it was an administrative agency and not a legislative judgment about limiting campaign contributions. So this is an administrative agency trying to say, you know what, Congress, you're wrong. When Congress says you can give a $2,600 contribution to somebody running for the U.S. House or U.S. Senate, the SEC's come in and say, you know what, Congress, you got that all wrong, because in this situation, we, an administrative agency, think that a $150 contribution, anything more than that, is corrupting. And that's not right.
Well, hold on a second. Hold on. They're not saying that you can't make the contribution. And that's a very important distinction here. Everybody is free to make whatever contribution they want. What they're saying is they don't want that contribution being made to someone in a position to line your pocket as the contributor. And I do think that there have been very reasonable time, place, and manner restrictions placed on the way individuals can make contributions. And the spending authority has always been allowed to put whatever strings it wants. So if government wanted to say the only way I'm going to spend money or engage a contractor to provide a service is if they use only black lead pencils as opposed to blue, they could do it. So I think in this case, if you or I want to make a contribution to a candidate, as long as we're within the federal election limitations, we can. The fact that that now means that your employer, who happens to be an investment advisor, is locked out, well, that's a condition of the spending authority of that particular state. Or in this case,
go ahead. Hang on one sec. Jason, go ahead and answer up, please.
Yeah, I mean, in this case, what it is this is the SEC saying you can either choose to exercise your First Amendment right, or you can choose to do your business. And that's not an acceptable restriction under the First Amendment.
At the end of the day, though, isn't this really all about, in many ways, and again, I still need to come back to this, because campaign contributions often do lead to bribery, and they often do lead to people doing things that are illegal. So isn't it really important to point out to the general public, the voters themselves, that whatever is happening here and why it's happening, it is meant to ensure that their elected officials no longer use money for their own ill-gotten gain? Jason.
Well, that's true. And guess what? In most of the cases that the SEC has cited to justify this rule, most of them involve payments that weren't campaign contributions. In fact, the vast majority of them involved contributions that weren't campaign contributions. They were direct payments to the candidates, or otherwise surreptitiously hidden payments to their family or to others. In this case, we're talking about 100% disclosed campaign contributions, where you're going to find out within a couple of weeks of the contribution being made exactly who made it, when they gave it, what date they made it, and exactly what amount of the contribution they gave.
Greg,
and that's what we're talking about here.
Greg, 30 seconds. Final thought to you on this.
Well, again, we're talking about how do you prevent a conflict of interest, right? because whenever an individual uses money to influence or gain access, which the court has said you can gain access, it creates a conflict of interest for the money manager as well as for the candidate. It's interesting that if you look at the public record, many money managers give to both sides. And if that's the case, really what you're saying is they want a level playing field. And there's two ways to have a level playing field. One is everybody gives, or the other is nobody gives. And I think in some respects, that's what the rule does, is it levels the playing field and it eliminates what has been determined to be a corrosive influence.
We'll have to call that the last word. And I agree with your phrase on corrosive influence as well. That's what the American people look at on a daily basis. Jason Torchinsky, Gregory Nowak, thank you so much for joining us. I have a feeling we will be here again very soon.
Thank you.
All right, thank you very
All
much.
right, gentlemen, thank you. Later on this hour, a new book about Benghazi points to someone in the CIA who held up what could have been a life-saving operation. We'll cover it on MidPoint, where we question everything.